In 1942, the case of Gajanan Moreshwar versus Moreshwar Madan shifted the application of Indian indemnity law. It moved the court's focus from literal interpretation of loss toward a standard of equitable protection. The events trace back to 1934 in Bombay. The plaintiff, Gajanan Moreshwar, secured a 999-year lease from the municipal corporation for a plot of land. Plaintiff transferred the lease to defendant Madan, who soon owed supplier Keshav Das Mohandas 5,000 rupees. Plaintiff deposited his title deeds as security. Missing the January 1938 deadline, Madan requested another 5,000 rupee charge, giving a written undertaking accepting personal liability. When promises went unfulfilled, the plaintiff's property remained burdened by a debt he did not incur. He sued to be indemnified and discharged from the liability. The Bombay High Court had to decide at what point a person is actually entitled to the protection of an indemnity contract. Does the right to sue begin the moment a liability becomes absolute and legally certain, or must the indemnity holder suffer an actual physical loss, meaning they pay the creditor themselves, before they can seek relief under the law? The ruling would determine if the law intervenes to prevent an impending debt or only to reimburse financial ruin after it happens. The court looked first to Sections 124 and 125 of the Indian Contract Act. Section 124 defines indemnity as a promise to save a party from loss. However, English equity principles allow for protection before a loss occurs. Justice Chawla had to decide if the Indian statutes were exhaustive or if these broader equitable principles still applied. The defendant argued for a literal interpretation. Because the plaintiff had not yet paid the supplier, there was no loss under Section 124, making the suit premature. The plaintiff argued that the contract was a promise to keep him free from the burden of the mortgage entirely. Once the debt became due, the defendant had an immediate duty to clear it. Pause the video here to consider the language. Does indemnify mean reimbursing a loss or preventing it? How would you roll? This tension between strict statute and practical protection defined the court's reasoning. Justice Chawla observed that the Indian Contract Act is not an exhaustive code. It defines only one specific type of indemnity, that caused by human agency. Where the act is silent, Indian courts are entitled to apply the principles of equity and common law to fill the gaps. The court identified a contradiction in the defendant's argument. If an indemnity holder is required to pay a debt before suing, but lacks the funds to do so, they face insolvency before the law can intervene. The ruling held that the duty to indemnify is a duty to prevent a loss from occurring once a clear obligation exists. By this logic, the value of an indemnity right is preserved only if it protects the holder before they are forced into payment. The Bombay High Court ruled in favor of the plaintiff, holding that Gajanan Moreshwar was entitled to be fully indemnified. The defendant was ordered to pay the mortgage amounts directly to the creditor, securing a release of the plaintiff's liability. Here is your summary of the precedent. First, liability commences the moment an obligation becomes absolute. Second, an indemnity holder needn't wait for actual financial loss to seek court protection. Finally, the Contract Act is not exhaustive. Courts apply equity to prevent loss. This case remains the anchor for equitable protection in Indian law.